Balancing AI safety and competition law. EU competition law may discourage and prevent collaboration on AI safety, whilst not being comprehensive or strong enough to maintain healthy competition in the industry. To illustrate the importance of competition, let's look at Gazprom. At a point, it exported 40% of the EU's natural gas supplies, giving it significant market power and making the EU dependent. It abused this power by cutting off gas supplies to Europe in retaliation for supporting Ukraine. This has been described as attempted blackmail by the European Commission. These disruptions caused very serious consequences like an energy crisis. Market power can translate to power over consumers and states. Gazprom's abuse of power was limited as there were numerous relatively quick to mobilize alternatives to natural gas, like solar energy. However, this situation would not be as simple with an AI monopoly, and it would be absolutely disastrous with a transformative AI monopoly. A TAI monopoly would have extreme leverage over the EU. Why? Because there'd be fewer quick to mobilize alternatives, primarily because there's no competition in the industry. And we'd also be highly dependent on the monopoly's TAI. This means that the monopoly would have extreme power over governments and consumers. If it abused this power, there would be egregiously harmful consequences. While some may argue that an AI monopoly would be able to innovate more and be more easily regulated, these are theoretical claims that are outweighed by the real risks of lack of competition and heavily contradicted by history. In the long term, it's better to maintain competition to incentivize and allow innovation across the whole industry to prevent an AI monopoly. Proposals to strengthen competition law and tailor it to AI. I want to focus particularly on implementing asymmetrical ex-ante regulation for the AI industry. Currently, EU competition law is based on symmetrical ex-post rules. In other words, actions only taken after the abuse of power has occurred. Worrying levels of market concentration in the digital sector signal competitive dysfunction. Thus, this ex-post approach must be changed if we want to preserve democracy. This change comes in the form of asymmetrical ex-ante regulation, which targets certain sectors of activity which, being conducive to market failure, require greater public intervention than an ex-post approach can provide. Moving on to AI safety. Companies lead AI research and development. Thus, cooperation between competing AI companies is likely necessary for safe, responsible development, deployment, and employment of AI. Thus, collaboration on AI safety is important. Nevertheless, current competition law is too vague, dissuading cooperation. It's also inflexible, preventing certain kinds of cooperation that would actually be more beneficial than harmful. Solutions. My proposed policies for and reformations to competition law for AI safety cooperation would be contained in an independent chapter added to the existing horizontal guidelines. This particularly allows regulation to be precisely tailored for AI and its unique features as both an industry and a rapidly evolving technology. It also incorporates a long-term perspective and makes competition law more dynamic and flexible. The safety cooperation chapter would include a safe harbor for AI standardization agreements. This safe harbor would allow for more straightforward interpretation and a more tailored approach to standard setting for AI. And it also presents a possibility of a label certifying whether a company has met certain standards for safety. This verifies that an AI product is safe, which is important as consumers may not fully understand AI's technical aspects. Another thing I have created in my chapter is unique special allowances, otherwise known as USAs. These are specific allowances for certain kinds of unique AI safety agreements or cooperation that are otherwise illegal under competition law that have been assessed and balanced to allow effective, socially beneficial cooperation on AI safety that would outweigh any anti-competitive effect. The chapter also includes an ex-ante assessment policy of USA proposals. AI companies can propose AI safety agreement ideas that they believe to have socially beneficial effects that would outweigh any cost of competition. The benefits of this policy is that companies can be more open to different forms of safety collaboration. It also serves as a clear guide for companies looking to collaborate on AI safety and saves time. Importantly, it makes competition law more flexible and adaptive to the evolution of AI, which may present more novel challenges and characteristics that aren't already taken into account by competition law. It would also facilitate more unique proposals like the assist clause and the windfall clause. In the long run, these policies help advance AI safety and could prevent any one AI company from accumulating excessive power over the EU government and consumers. Additionally, if adopted by the European Commission, the Brussels effect may occur to spread the influence of these policies globally.